Good afternoon. My name is Kristin Hausler, and I'm the Dorset Senior Fellow, and I lead the Center for International Law here at the British Institute of International and Comparative Law. And it's a great pleasure to welcome you all for this very special lecture today. So this is the Weinrebe Annual Memorial Lecture. It's a lecture we've had now for quite a few years, and it's the third year, I think, actually, that we're hosting it along with Dubois and Plimpton. So we're very grateful for the support for this special lecture that has become a staple in the year for us, a very important event. So we also, of course, very grateful to the Dorset Foundation because they are supporting the program and the research program of the Center for International Law and have done so for several years. So it's also for us a way of honoring the memory of Harry Weinrebe, the philanthropist who was behind the Dorset Foundation. We are, of course, a charity, so we are very grateful to the Beauvois for having sponsored this event today, allowing us to host it free for you all. There will be also a reception on the lower ground floor. We'll direct you later on, so please do stay with us for some canapés afterwards and discussion and a networking opportunity. As a charity, of course, we welcome the sponsorship and any gifting that may come our way. Our team has just set up there a new gifting board. So if anybody's feeling also generous tonight, do feel free to inaugurate it and use it. Now a few house matters before I introduce the chair for this event. In case of fire, we do not expect a fire drill, but I do have to let you know that in case you hear the fire alarm, you should make your way out of the building using the stairs, and we will meet at a statue which is around the corner there, so you can just follow some of our stuff if that happens. But now I will turn to our chair for this evening. Samantha Rowe is a partner in the International Dispute Resolution Group at the Beauvois and Plimpton. Her practice focuses on international arbitration and public international law. She's a member of the firm's ECJ leadership team. She has experience across quite a wide variety of sectors, including energy, mining, construction, financial services, pharmaceutical, and many more. She has been named, and I really like this, to the Lawyers' Hot 100 list as one of the most innovative and inspirational lawyers and a rising star in several awards as well. She is really a true international lawyer. She's gained a degree in English and French law from Oxford, but also from Paris 2. She also has an LLM from NYU. She has been admitted to the New York Bar and has been practicing there. So really a true international lawyer. And we are, of course, last but not least, we have to say our thanks to Sam because she has been behind one of our quite successful recent initiative, the Honorary Practice Fellow Initiative, and one of the first honorary fellows. She's been really the driving force behind this initiative, and she's also a member of our BIICL advisory panels. We're always very grateful for your time, and it's a pleasure to have you today. And I will now leave it to you to introduce our distinguished lecturer for tonight.
Thank you, Kristin, for that incredibly kind welcome. And really a huge thank you to BIICL for all the hard work that's gone into organising tonight's event. And on behalf of Beauvois, we are delighted once again to be supporting the Weinrebe Annual Lecture and to continue to facilitate these kinds of important discussions in this sort of open forum as well. Now, I have the pleasure of introducing tonight's speaker, Tim Eicke KC, and we're truly honoured to have Tim with us this evening. As many of you will be aware, Tim has very recently, just 4 weeks ago, returned to the bar in London following his 9-year term serving as the UK's elected judge at the European Court of Human Rights from 2016 to 2025. So not an uneventful period in the court's history. And as we celebrate the 75th anniversary of the convention this year, it's particularly apt that we place a spotlight on the critical role of the convention and, of course, of the court. And we look forward to hearing directly from Tim about his experiences in Strasbourg and his reflections on the continuing importance of the convention during these challenging times. It would be remiss before handing over to Tim not to highlight some of the significant cases that he oversaw as a judge at the court. For example, Tim was part of the Grand Chamber deciding on state obligations in respect of climate change and large-scale environmental pollution. He notably issued the sole dissenting opinion in the Varane and Switzerland judgment, questioning the court's legitimacy in creating new rights to protection from the harmful effects of climate change. And he also heard many cases against Russia brought by Georgia and Ukraine in respect of armed conflict, including the downing of MH17 by Russian-backed forces. So it's therefore no exaggeration to say that Tim has decided cases which confront the most pressing human rights issues of our time. And having participated in over 800 reported judgments, advisory opinions, and decisions of the court, Tim has been an instrumental figure in the development of modern European human rights law. Even before his time at the court, Tim was one of the leading advocates in public law, EU law, international human rights law, and public international law. And I'm sure I speak for everyone in the room in welcoming Tim back to practice, back to London, and we all look forward to working with you in the future. But for now, please join me in extending a very warm welcome to Tim, and I will hand the floor over to him.
I hope this works. Thank you very much, Sam and Kristin, for that slightly overwhelming introduction. Thank you to BIICL for the invitation to speak to you today, to the Dorset Foundation for supporting, and to Deborah Voice and Plimpton for sponsoring this event, and to Sam for moderating this evening. It's an honor and a privilege to address such an eminent audience tonight and to follow such eminent previous speakers of the Weinrebe Lecture. When Kristin and I first discussed the possibility of me giving this year's Harry Weinrebe Lecture and agreed on the title Reflections from the Strasbourg Bench, I dared to hope, if only for a moment, that my reflections here tonight might focus on some of the highlights of the Strasbourg Court's engagement with general public international law during my 9 years at the court. Cases which I always found most interesting and rewarding, and of which I am very proud to have been part. This might have included some of the older and perhaps lesser known examples, such as Knight Lehman against Switzerland, engaging in some detail with the state of the law in Article 14 of UNCAT and customary international law in relation to the existence or not of a duty on Switzerland to entertain a civil action for damages in relation to torture allegedly committed in Tunisia. Or Molasali against Greece, in which we considered the relationship between the convention, as we heard, drafted and signed 75 years ago, and the 1913 Treaty of Athens, the 1920 Treaty of Sèvres concerning the protection of minorities, and the 1923 Treaty of Lausanne. And just for good measure, in the just satisfaction judgment, there was also some discussion of the monetary gold principle in the context of providing just satisfaction for properties located outside the respondent state. Or perhaps the 2021 decision on the competence of the court to give an advisory opinion under Article 29 of the Oviedo Convention, in which the court, for the very first time, had to consider whether to accept the request for an advisory opinion under another treaty, here the Oviedo Convention, which other international courts, of course, do with some regularity. And of course, recent judgments like Klimasenioren in the climate change case, Semenya on international sports arbitration, and the conflicts against Russia would, of course, have also featured. And I will return to the later cases briefly at the end of my talk. But the more time passed and the more I reflected on what to talk to you about, the more it became clear there were other more pressing issues concerning the court which deserved being addressed head on. After all, the European Court of Human Rights, which it has been the honor of my life to serve on for the last 9 years, is again the subject of widespread debate, both here and abroad. A debate in much of which I hardly recognize the court in which I so recently served. And therefore it saddens me that the reflections I want to share with you and the structure in which I present them are almost by necessity defensive rather than, as I think they should be, celebratory. And this seems even more poignant as we are As many of you will appreciate, and Sam mentioned, we're approaching the 75th anniversary of the convention itself, signed on the 4th of November, 1950 in Rome, and have just passed, without much fanfare, the 25th anniversary of the entry into force of the Human Rights Act on the 2nd of October 2000. Now let me turn to the court and its work, and I want to start by putting it into context. And again, I apologize if some of this may seem basic. It may well be known to some of you. But in light of the fact that there appear to be significant misunderstandings which underlie, or, and I hesitate to use this term, inform the current debate about the convention and the court, I hope it is nevertheless helpful, if only by setting the record straight. Now, as you will know, the European Convention and its court cover some 46 member states across the whole of the European continent, from Armenia and Azerbaijan in the east to Portugal in the west, from Iceland in the north to Cyprus in the south, covering some 700 million people. The only exceptions famously are Belarus and Russia, and of course the Vatican. Now, this was not the situation when I arrived in Strasbourg. In September 2016, there were 47 states parties to the convention, including Russia. This only changed very rapidly when Russia was excluded from the Council of Europe and consequently from the convention in response to its invasion of Ukraine in February 2022. But as we will see, it is because of its prior membership and of the mechanisms governing the term of Russia's exclusion from the convention that the court therefore continues to this day to have pending before it a significant number of applications against Russia. In fact, one just satisfaction judgment was only handed down today. By reason of its membership, the court consists of 46, formerly 47 judges, one in respect of each contracting party. And the judges are, and again in the current debate this bears emphasizing, elected by MPs who are themselves, of course, largely elected and represent the national parliaments of all the member states assembled in the Parliamentary Assembly of the Council of Europe. In their daily work, the judges are supported by approximately 600 staff lawyers employed by the court's registry, lawyers who are deeply familiar with the national legal systems and cultures of the different member states. In fact, these lawyers, who are some of the most talented lawyers I've ever worked with, are absolutely essential to enabling the court, which works only in its two official languages, French and English, to deal efficiently with the enormous number of applications it receives. Applications which are more often than not written in and complain about administrative and judicial decisions made in any of the about 38 other non-official languages of the member states. The enormous case law of the court, of course, arises primarily from the fact that, unusually for an international court, Article 34 of the Convention provides for a compulsory jurisdiction in relation to individual applications to the court. This means that, subject to certain admissibility requirements, such as the need to have exhausted domestic remedies, every affected person, non-governmental organization, or group of individuals within the jurisdiction of a member state, claiming to be the victim of a violation of the rights in the Convention, has the right to apply to the court and to have that application considered and decided. The Convention provides no filter and, importantly, no provision or procedure, as exists, for example, in the US Supreme Court for certiorari, procedure to enable the court to in any way select the nature or subject matter and or to limit the number of the cases that come before it and which it is required to decide. Like most national, certainly first instance courts, the court's output is therefore ultimately determined by the nature of the complaints and, dare I say it, by the very variable quality of the representations of and the submissions made by the parties to it. Now, in addition to the individual applications, there's also provision in Article 33 for interstate applications, by which one member state may refer to the court any alleged breach of the Convention by another member state. Now, this is, of course, the very mechanism by which Ireland, only last year, lodged proceedings against the United Kingdom to challenge the enactment and operation of the Northern Ireland Troubles Legacy and Reconciliation Act 2023. As of today, this case remains pending before the court. Curiously, though, this pending case is rarely, if ever, referred to or even acknowledged by those calling into question the importance of membership of the Convention and or access to the Strasbourg Court in the context of the Belfast Good Friday Agreement. Now, when I referred to the enormous number of applications, let me give you some numbers. While there are only 15 interstate applications currently pending before the court, they constitute a numerical, though not in terms of importance or in terms of demand on judicial and other resources, negligible aspect of the overall 62,850 applications pending before the court at the end of August this year. This number of pending applications compares with the court having disposed, by means of a judicial decision, either by a single judge, a committee of 3 judges, a chamber of 7 judges, or a grand chamber of 17 judges, of some 36,819 applications last year alone. Out of these 36,000 plus applications, some 25,990 were declared inadmissible or struck out following friendly settlement or a unilateral declaration. The remaining 10,829 applications were the subject of 1,100 judgments, of which the vast majority was adopted by a committee of 3 judges. And there it's perhaps important to note that committees can, on the one hand, only decide matters already covered by the court's well-established case law, and as a result, their decisions or judgments, therefore, are not intended to create and should not be treated as having created any new precedent. It is noteworthy that despite its enormous output, there are only ever 1 or 2 judgments a year, and which ones, of course, may vary from country to country, which come to public attention and which generate political debate. More often than not, the court's judgments are accepted without even a passing comment. Now, just to put these numbers into a more personal context, my rough calculations suggest that during my 9 years at the court, I was party to, and Sam mentioned about 800, but I think I'm making it 950 reported judgments, advisory opinions, or decisions, and declared more than 3,200 applications inadmissible as a single judge. These applications covered a vast range of national legal systems, as well as subject matters, from banking resolution, regulatory and tax law, VAT, bioethics, and historical injustices, to the conduct of armed conflicts, Russia-Ukraine, Russia-Georgia, Armenia-Azerbaijan, but also the exercise of power by German troops in Afghanistan. From immunities, parliamentary, diplomatic, international organizational immunities, and the legality of covert intelligence or bulk data interception, to the application of the ECHR to climate change and international sports arbitration, criminal law and procedure, international child abduction, family law, mental health, and modern slavery, to name but a few. And yes, they also did cover immigration and extradition. But these were only, in my case at least, a relatively small part of the work, and arose mostly, or most frequently, in the context of single judge decisions, declaring complaints inadmissible. Now, the reason I'm spending this time to look at the figures in detail is also to contextualize the UK position before the court, and therefore the current debate about the court and the convention and its asserted impact on the UK. After all, nearly 60% of the more than 62,000 applications currently pending relate to only 3 states. That's 21,800 applications against Turkey, that's 34.7%, 7,450 applications against Ukraine, that's 11.8%, and 8,300 applications are legacy cases against Russia, that's 13.2%. By contrast, at the end of 2024, the UK had 274 applications pending against it before the court, amounting to, and we love this metric, 0.07 applications per 10,000 inhabitants, which puts us just behind Ireland and Germany. The previous years, it had always been at 0.04, and therefore the lowest per head count of applications amongst any of the 46 and previously 47 member states. In fact, in 2022, the court handed down only 3 judgments against the UK, of which 1 was a friendly settlement and strikeout, 1 was a finding of no violation, and only 1 contained at least 1 finding of a violation. The remaining applications will have been declared inadmissible or struck out by decision of a single judge or a committee. The 1 judgment that did find a violation concerned a breach of Article 10, the right to freedom of speech, arising out of the award of a success fee element of a cost award in defamation proceedings brought before the courts of England and Wales. The successful applicant in that case was, of course, Associated Newspapers Limited, the publishers of the Daily Mail, Mail Online, and the Mail on Sunday. Now, it may not surprise you to hear that this was not the only occasion when someone critical of the court and of the convention, and possibly even advocating leaving the convention system, sought the protection of the court when they considered their human rights to have been violated and by definition, therefore, not having been adequately protected by domestic or the common law. Now, in my experience, the primary reason why there are and have been so very few applications and even fewer successful applications against the UK lies largely in the fact that under the Human Rights Act 1998, the UK courts and tribunals generally do such a good and thorough job at interpreting and applying the convention that there's little the court in Strasbourg can improve on. Now, while I want to return to the question of the convention not providing or having provided protection beyond that which the domestic law or the common law is able to or willing to provide in a minute, I want to say a little more on the ECHR impact in the specific context of migration. And here I can do no better than refer to the work done recently by Oxford University's Bonavera Institute, one of whose author is in the audience. On 4th of September, the Institute published a report which has had surprisingly little coverage in the press, entitled The European Convention on Human Rights and Immigration Control in the UK, Informing the Public Debate. That report rightly highlighted the following important facts. One, the Convention contains no express provision preventing the removal of non-citizens. In fact, I would add that the court goes out of its way to reiterate at every opportunity that, and I quote, "The state is entitled as a matter of well-established international law and subject to its treaty obligations to control the entry of aliens into its territory and the residence there. The Convention does not guarantee the right of a foreign national to enter or to reside in a particular country," end quote. And secondly, I would add that the right to political asylum is not contained in either the Convention or its protocol, and the court does not itself examine the actual asylum application or verify how states honour their obligations under the 1951 Refugee Convention or, where applicable, European Union law. The Institute's report secondly highlighted that since 1980, that is in the last 45 years, there have only been 29 ECHR judgments against the UK concerning the removal of foreign nationals from the UK. In 16 of these cases, the court found that the proposed deportation or extradition would not breach the Convention and could therefore go ahead. In 13 cases, the court found that the deportation or extradition would violate the Convention. However, in only 4 of those 13 cases was the court concerned with Article 8, the right to respect for private life. And in the same period, there have only been 3 judgments in which other aspects of the UK immigration rules have been found to violate the Convention. In fact, it bears emphasising that the court has repeatedly stated, including prominently in cases against the UK, that it would not substitute its conclusions for those of the domestic courts, which had thoroughly assessed the applicant's personal circumstances, carefully balanced the competing interests, and took into account the criteria set out in its case law, and reached conclusions which were neither arbitrary nor manifestly unreasonable. In these cases against the UK, the court has also repeatedly refused to accede to submissions made to it by applicants and/or third parties to the effect that the already existing and very detailed domestic law provisions governing how immigration tribunals should apply and assess Article 8, as introduced by the 2013 Immigration Act and the 2014 changes to the immigration rules, were such as to, in effect, prevent a meaningful proportionality assessment at all, and therefore amounted to a systemic violation of Article 8. In fact, in its 2022 judgment in Otite, having found that the upper tribunal had not conducted the necessary balancing exercise by reference to the case law of the court, but had limited its consideration to the unduly harsh and very compelling circumstances test set out in the 2014 provisions, the court nevertheless conducted its own balancing exercise and concluded that this deportation would nevertheless not violate the Convention. Now, let me be clear, I do not want to be understood as suggesting that the problem, whatever that is, lies with the domestic courts rather than the Strasbourg court. Far from it, my experience at the court and through my continuous engagement over the last 9 years with the domestic judiciary has confirmed over and over again that the domestic courts, whether it be at tribunal level or above, in applying the Convention faithfully, also give fullest effect to the public interest in removal, deportation, or extradition, an interest expressly protected by Article 8.2. This, again, it seems to me, is reflected in the extremely low number of admissible applications and even lower number of findings of a violation against the UK. In light of these facts, one cannot help but wonder whether the problem with the debate, or even the underlying problem, insofar as it is one, might lie elsewhere. And here it may be worth noting two things. One is that, as the Bonavera Institute report notes, there is in fact no up-to-date published data on human rights-based appeals against deportation decisions generally, and no data at all on the number of human rights-based appeals which, even were successful at first instance, have been overturned on appeal. The last available general data only runs to June 2021. And for what it is worth, the authors note that that data shows that between April 2016 and June 2021, while there were some 922 successful human rights appeals to the first-tier tribunal, and again, note, without any indication whether that might have been overturned on appeal, at the same time, there were some 26,091 foreign national offenders who were deported. And secondly, Lord Wolfson, King's Counsel, the Shadow Attorney General, in his very recent advice to the leader of the Conservative Party, records that at the end of March 2025, there were 78,745 asylum applications waiting for an initial decision, as well as some 50,000, nearly 51,000 open asylum appeals before the first-tier tribunal. Now, if the problem does lie elsewhere, one cannot help but wonder whether the current debate, seeking to lay the blame at the door of the convention, or the courts applying it, is not in fact an expression of a dislike for any enforceable human rights, especially where they come armed with judicial oversight. This question, of course, goes to the very heart of our understanding of the separation of powers and the rule of law, and ultimately the nature of our democracy. Now, apart from what appears to be happening across the Atlantic at the moment in relation to forced removals and deportations, closer to home, the need for such judicial oversight was perhaps no one more evident than in the context of the so-called Rwanda scheme. As you will recall, in the context of the operation of this scheme, the Strasbourg court, at very short notice, indicated to the UK government under Rule 39 of the Rules of Court that the applicant, one NSK, should not be removed until the expiry of a period of 3 weeks following the delivery of the final domestic decision in the then ongoing judicial review proceedings. And again, I want to be clear, the court did not stop the flight. Its indication was specifically directed to this one and subsequently one other applicant. But once they had been removed from the plane and following the grant of a number of further interim measures by the domestic courts, the plane ultimately did not take off. The primary reason why I mention this incident is, however, a different one. And it is to note that already at the High Court, the decision to remove NSK was quashed for the failure by the decision maker to provide adequate reasons for the decision that his asylum claim was inadmissible. But perhaps even more noteworthy were the decisions in the same judgment in relation to some of the other applicants, such as AAA, where the decision was quashed because it had taken into account the wrong facts. Or even AHA, where not only was the decision based on the wrong facts, in fact, AAA's evidence had accidentally been transposed into the decision made on his case. The decision maker had also failed to consider AHA's written representations. As far as I'm aware, none of these decisions on the substance of the individual cases were ever appealed. And of course, ultimately, in its decision on the Rwanda scheme, the United Kingdom Supreme Court quashed the scheme on the basis of the non-refoulement principle, which it made very clear did not primarily find its origin in Article 3 of the Convention, but was in fact a core principle of international law to which the United Kingdom government had repeatedly committed itself on the international stage, consistently with this country's reputation for developing and upholding the rule of law, and which was given effect to by numerous international conventions, including the Refugee Convention, UNCAT, and others, to which the UK is a party, and possibly also by customary international law. Now, without effective judicial oversight over these decisions made in the individual cases, it seems clear There are substantial grounds for believing that individuals, including NSK, AAA, and AHA, would have been deported to a real risk, as the Supreme Court established, of torture or inhuman or degrading treatment. This leads, of course, to the fundamental question whether deliberately exposing individuals, no matter how otherwise objectionable they may seem to be, to a real risk of torture, inhuman or degrading treatment, or to do so without a careful consideration of their cases or circumstances, would or should still be acceptable in 2025. However, it is clear in any event, at least clear to me, that there just is no evidence that, even if it were acceptable in principle, the numerical challenge, which I understand the Conservative Party has recently put at 150,000 individuals per year, or 750,000 individuals over the term of a parliament, could even remotely be met by removing this most fundamental protection. In fact, the evidence I've seen so far clearly points the other way. Now, as we are at Rule 39, let me just say a few more words about Rule 39 indications, because, as you will know, they have also been the subject of sustained criticism. And again, I do so from the point of view of someone who, over 4 years, was one of the duty judges responsible for deciding, and therefore on call every working day to decide on Rule 39 applications, and who, as a result, has in that time had to decide more than about 800 of those applications. I should add that under the rules of court, I was not responsible for Rule 39 indications against the United Kingdom. The first thing I would note is that that power to grant such interim indications is neither new or novel. In fact, this power, which is in principle only exercised in exceptional circumstances where there is an imminent risk of irreparable harm to a core convention right, plays a vital role in avoiding irreversible situations that would prevent national courts or the Strasbourg court from properly examining the convention complaints. Such a power to hold the ring, which exists in any developed judicial system, has been enshrined in the rules of procedure of the convention institutions, originally the European Commission of Human Rights, at the very least since its rules of 1975. Furthermore, experience has shown that governments have consistently accepted the exercise of this power by the court, and in fact the UK has consistently complied and has only once been held not to have taken all reasonable steps to comply with the Rule 39 indication. In fact, during my time, it was unfortunately also a not infrequent occurrence that member states themselves have actively sought such Rule 39 indications, in particular in the context of armed conflicts around Europe. In fact, shortly after the Rule 39 indication in relation to NSK was made, the court also granted Rule 39 indications in relation to 2 British nationals, Sean Pinner and Aidan Asley, who, having served in the Ukrainian armed forces, had surrendered to the Russian forces during hostilities and had been sentenced to death in the so-called Donetsk People's Republic. The Rule 39 indications addressed to the Russian authorities required them to ensure that the death penalty imposed on the applicants was not carried out, to ensure appropriate conditions of their detention, and to provide them with any necessary medical assistance and medication. Their issue in the form of a binding injunction were in fact positively welcomed by those otherwise critical of the court, and the Russian suggestion that Russia might not comply was somewhat criticized. Now, this context takes me to another very important aspect of my 9 years at the court, and that is the interstate proceedings adjudicating on Russia's increasing military aggression against its neighbors and fellow Council of Europe members. For the last 7 years of my term, I had the unusual privilege, if that is the right word, of having been intimately involved as part of the respective Grand Chamber compositions, as well as a duty judge, in all the resulting interstate proceedings, first in Georgia-Russia number 2, subsequently in Ukraine and Russia-Crimea concerning the invasion of Crimea in 2014, as well as in Ukraine and Netherlands against Russia concerning the fighting in eastern Ukraine in 2014, the shooting down of MH17 that same year, and the invasion of Ukraine in February 2022. The last of these judgments, which we handed down in July of this year, runs to some 501 pages and is supported by 2 annexes running to about 2,000 pages, summarizing the evidence considered by the court in reaching its comprehensive decision. Now, when one considers that to date, and probably for the foreseeable future, the Strasbourg Court has been and will be the only international court which has comprehensively engaged with the question of Russia's responsibility It's a matter of international law for the human rights violations that occurred in those conflicts. It is difficult to see how it can legitimately be said that the Convention or the Court have outlived their usefulness and are no longer fit for purpose. In fact, in this most recent case, some 26 states intervened in support of the application made by Ukraine, asking it to, and I paraphrase, hold Russia to account. In fact, some of them positively asserted that holding Russia to account for its conduct in Ukraine, and that of course was conduct that was extraterritorial and at the time at least arguably outside the court's jurisdiction, was, and here I quote from the Polish government's submissions as recorded in the judgment, critical to upholding confidence in and the relevance of the convention system as a living instrument capable of responding to the most significant of challenges. So the very concept of the living instrument, so vehemently criticized in the context of the migration debate as having extended the scope of the convention too far compared with the original intentions behind the convention, is here being invoked by one of the signatories to the letter sent by the heads of government of 9 member states at the initiative of Italy and Denmark in support of a positive submission that the court should, in fact, extend its jurisdiction. It is perhaps not surprising, therefore, if I confess to being puzzled as to what the court is, in fact, being criticized for. Either it can and should apply in a careful, cautious, and gradual manner an evolutive interpretation. After all, that is all that the living instrument doctrine is meant to be, in order to remain capable of responding to the most significant challenges of our time. Or it should hew closely to what is asserted, without clear evidence, to be the original intention behind its creation. But it seems to me it cannot do both. Now, considering the apparently so contested concept of the living instrument, it is perhaps also worth noting that not only is it an expression of the international concept of evolutive interpretation of treaties, but it is, like so many aspects of the Convention, deeply rooted in the English common law. After all, it was the Privy Council in its 1929 opinion in Edwards and Attorney General for Canada which confirmed that constitutional instruments are to be interpreted as a living tree, capable of growth and expansion within its natural limits and not by a narrow and technical construction. In that case, the Privy Council decided that the term persons, for those eligible to sit in the Senate, and until then understood to refer only to men, could also include women. It was Lords Bingham and Brown and Stott who confirmed the identity approach between these two concepts. In fact, of course, arguably, this is no more than a focused expression of the very nature of the common law. After all, as Lord Gough chiefly described it in Kleinwood-Benson in 1998, judicial development of the common law is inevitable. If it had never taken place, the common law would be the same now as it was in the reign of King Henry II. It is because of it that the common law is a living system of law, reacting to new events and new ideas, and so capable of providing the citizens of this country with a system of practical justice relevant to the times in which they live. Now, there are, of course, those who say, perhaps as a result of its very nature, that the common law would be able to and would, in fact, provide all the protection to ordinary citizens which the Convention and the Strasbourg Court currently provide. Now, the living nature of the common law makes it rather difficult to deny that, perhaps today, having been infused with the experiences of adjudicating on human rights under the Convention and the Human Rights Act for now some 25 years, it might in fact do so. What we can, however, be absolutely certain of is that repeatedly over the last 70 plus years, especially before the entry of the Human Rights Act, the Convention organs stepped in where the domestic courts applying the common law were unable to provide the protection which we now take for granted or even cherish. Let me just give you a few examples. So despite the fact that the use of torture had long been declared illegal in England and Wales, it was the Strasbourg Court in its 1978 judgment in Tyro which held that birching as a form of judicial punishment, in that case on the Isle of Man, was a form of degrading punishment contrary to Article 3, not a result which I assume many would question today. It was also the Strasbourg Court's finding of a breach of Article 3 in its 1998 judgment in A in relation to acts by a stepfather which the domestic courts applying the common law had accepted as reasonable chastisement, which led to a change in the law protecting children from excessive punishment in the home. Again, it took the Strasbourg court judgment of 1981 in Dudgeon to ensure that homosexual conduct in private was finally decriminalised in Northern Ireland, something neither Parliament nor the common law had been able to do. And the 1999 judgment in Lustig, Prien and Beckett, which finally led to the demise of the Ministry of Defence's absolute policy against homosexuals in the British Armed Forces. Today, the armed forces rightly celebrate the fact that they are top-rated as employers of LGBT staff, and in 2023, following the Lord Etherton review, the government apologised officially for the treatment of LGBT veterans. And finally, perhaps, it was the positive obligations to investigate established by the court's case law under Article 2 and 3, which ultimately led to the reopening of the Hillsborough inquests and most recently to the Public Offence Accountability Bill, referred to as the Hillsborough Law, and of course the 1979 judgment in Sunday Times number 1, where the court held that the injunction imposed by the domestic courts was in breach of Article 10, and its lifting then facilitated the Sunday Times in exposing and reporting on the thalidomide scandal. Now that list could go on, but I think it makes the point. Now going back to the argument about the original founders, I want to close with two quotations, which in my view reflect very clearly what the founding fathers, because they were all men, really did have in mind when drafting the convention 75 years ago. The first comes from Pierre-Henri Teitgen, seen as one of the true driving forces behind the convention. He said during a session of the Consultative, now Parliamentary Assembly in September 49, and I quote, "Democracies do not become Nazi countries in one day. Evil progresses cunningly, with a minority operating, as it were, to remove the levers of control. One by one, freedoms are suppressed in one sphere after another. Public opinion and the entire national conscience are asphyxiated. It is necessary to intervene before it is too late. The conscience must exist somewhere which will sound the alarm to the minds of a nation menaced by this progressive corruption, to warn them of the peril and to show them that they are progressing down along a road which leads far." End quote. Now, just to show for balance that this was not only a sentiment pursued by the continental European negotiators, the second quote comes from Sir David Maxwell V of King's Counsel, who later, of course, became Home Secretary and as Earl Coolmuir Lord Chancellor, and who was one of the driving UK forces behind the drafting of the convention. At his speech at the 1950 annual dinner of the Grocers Society, he reflected upon the benefits of the convention just adopted and stated that, and I quote, "Anyone who has had to study the onset of totalitarianism would agree that there is a tide in the affairs of states which, taken at the flood, sweeps on its people and leaves them high and dry on the rocks of tyranny. Nevertheless, there's always a moment when the guiding lights of democracy and reason, though burning low, are not extinguished. The problem is how these lights can be tended in time. We believe that an impartial and objective examination by an international body of the alleged infringements of a generally accepted code of individual freedom would illuminate the dangers for all good democrats to see. We believe further that when the true implications of the situations are seen, a stand against the encroachments of tyranny would be made." End quote. Now, this is exactly the role the court did play during my time at the court in relation to Russian aggression in Europe and in relation to many other modern challenges, and I'm sure will continue to play. And it seems to me that if one observes the political developments in Europe and elsewhere, one might be forgiven for thinking that in fact the convention and the court, as the early warning system intended by the founding fathers, is in fact more important and more necessary today than they have been for quite some time. Thank you very much.
Well, thank you, Tim, for providing such a rich and impassioned and measured defense of the convention and the role of the court. Chair's prerogative, I'm going to ask you the first question and then I will open it up to the floor because I'm sure there'll be lots of people out there who want to talk to you about the topics you covered and maybe others as well. But picking up on perhaps the elephant in the room or the encroaching shadow of the relationship between the court and the United Kingdom. And I want to pick up on 3 threads from your lecture. So the first is, you very rightly identified the low number of admissible and successful applications against the United Kingdom, and you credit the role of the domestic judiciary in interpreting and implementing the convention, especially under the Human Rights Act. At the same time, you talked about the Supreme Court decision in the Rwanda case and the fact that the court was at pains to base itself not on the convention, but on other treaties and customary international law. And then finally, that sort of beautiful parallel that you drew between the convention as a living instrument and the development of the common law as well. There's obviously quite a complex relationship between our law and convention rights. And I just wondered if you could maybe speak a little bit further about the integration of the convention into UK law, and the future role of the convention in our legal system, including if we were ever to withdraw.
That's quite a complex question on a complex relationship. I think there are a number of reflections I think I would have. I have the privilege as a very junior barrister to be part of the team under Sir Stephen Sedley, the Lord Justice Sedley, to travel the country to train judges on the use of the Human Rights Act, having been party as counsel and as pupil to some of the litigation beforehand, and therefore seen the Human Rights Act from its inception, and always experienced it as counsel too, as a pendulum, as a dialogue, which had come, I thought, in 2016 when I left, to a fairly healthy and good place. Still swinging a bit, but it was quite comfortable until the political debate took a different turn. Looking into the future is actually really difficult in that context. My own sense is that leaving the convention, even though sought to be portrayed as a relatively straightforward and simple matter, is of such complexity that I desperately hope that that's not something that would be undertaken, and would hope that we remain a state party to the convention. And that is in part for our own interests, but also in part because, and again, this was my experience of having served there for 9 years, the UK also has so much to contribute to the convention as a European institution and mechanism to ensure the protection of human rights across the 46 now member states. And in fact beyond, because every now and then you hear that the Korean Supreme Court will have cited a decision of the Strasbourg Court and changed its law on the basis of that, or the Japanese Constitutional Court will have looked at our decisions and been persuaded to go and change their approach. Would, if we left the common law, provide the protection? As I said in my talk, that's difficult to say, because of course the common law is by its very nature a living doctrine, which has always adopted strange things in order to make a problem, to solve a problem for which the common law at that stage had no answer, and therefore has constantly developed. As we talked briefly before, and I remember being at one point asked to advise when I was just in Silk, and I was asked to advise by a foreign common law jurisdiction, to advise them on what the English common law on a certain point would be shorn of all the European influences. And I just had to shrug my shoulder and say, well, actually, that's not possible, which is, I think, why the common law in each jurisdiction develops differently and separately, because the common law is by nature that. Would therefore, having absorbed all that human rights jurisprudence and absorbed it so well over the last 25 years, I don't think the common law will ever be the same again, and will not go back to where it was in 1998 or 2000. But it's also clear that there won't be 100% cover, as we see from the few cases in which violations are still found today.
going to claim that as a partial victory for optimism. Any questions?
Have you found in your experience that that Strasbourg jurisprudence was influenced by excellent arguments from common law lawyers, of which there were not that many, I don't think. There are not many common law countries. Ireland, UK.
That's when it becomes tricky. I once talked to a Maltese judge and said that tried to claim them as another common law jurisdiction. He nearly bit my head off. So I think that's tricky. I think the only two which are clear is Ireland and the UK. Again, in parts, but not wholly, I think. And yes, it has, and that's partly through the judges and the lawyers who work at the court from those jurisdictions with those experiences, but probably more importantly from the advocates who present cases before the Strasbourg court. Both the bulk of our cases is in written proceedings, but even in written pleadings, but even more so in oral pleadings. When I was at the bar, we were always told, kind of, everybody says the UK lawyers or common lawyers are the best. But having sat on the bench in Strasbourg, actually the advocates by common law advocates have by and large been much superior to the arguments we heard from others, the way they were presented, the way they engaged with and synthesized the issues we as a bench were interested with. And frequently I would walk out of court and my colleagues kind of would tap me on the shoulder and say, "God, that was impressive," or "That was good." So that's one element, which is also one of the elements or reasons why so many UK advocates are instructed in cases not against the UK or not involving UK parties, because their effectiveness as advocates is very good. And the other is the quality of the jurisprudence coming out of the common law courts, and particularly, and that's in part because of its size and its visibility, not by reason of the quality of the work the Irish Supreme Court does, which is extremely high and very influential when the court notices it, but the UK Supreme Court, and in parts the Court of Appeal or the Inner House in Scotland, or even the Court of Appeal in Northern Ireland, who, because they all write in English, because they all write in such detail, in such careful analysis of the competing arguments by reference to, and that's another reason why the UK Supreme Court is more influential, because it does so by reference to the text of the convention and the court's case law. That is hugely persuasive, even in cases not against the United Kingdom. So yes, I mean, the common law, considering out of, when I arrived, 47, there was only 2 of us. And now it's 2 out of 46, doesn't make it much better. The common law influence on the structure of the system, on the way the court operates, and on its case law is out of all proportion to the number of common lawyers in the buildings.
Thank you so much, Tim. I have a question which was actually prompted by a piece in the Times this morning, which I'm sure you've seen, about, claiming to say that the UK government was moving towards the idea of some sort of amending or additional protocol to the convention. As always with media reports, very sort of confusingly worded or loosely worded. So I'm not sure that we really know what the position or settled position of the government is. But I suppose my question is, given the range of available options, possibly of an additional protocol that wouldn't need a unanimous ratification, or possibly some sort of declaration by a certain number of states. Well, what do you think the most likely options are, and indeed, how would they be received by the court, should we say, in terms of the actual likelihood of the states that are, the group of 9 now enlarged to, we gather, about 16. it seems clear to me that they're actually addressing their domestic audience. This is an attempt to externalize blame and responsibility onto the court in a very misguided and regrettable way. But, you know, regardless of the motivation, where do you think this might end up, with a protocol or a declaration or something, and how would that then be received by the court?
Yeah. Thank you for that. And can I also thank you for the Bonavera report, which you were part of, which was greatly appreciated. Thank you. I think that's I should preface this by saying that the court has deliberately been very careful and reticent to comment on the letter of 9. So I'm not speaking for the court, and I will be careful. But even where I'm less careful than the court, I'm not speaking for the court. I saw that headline, but like you, over the last 9 years, and you mentioned it wasn't a trouble-free period, I've learned to kind of wait to see what actually comes out in terms of a document. But what are the options? So in practical terms, the option, of course, would be a protocol, which could either seek to amend any of the substantive provisions. But in order for that to have any meaningful effect, one assumes, and I haven't thought this through, one would assume that that would have to be ratified by all member states. So that could be an amendment to Article 8 or Article 3. I mean, you could introduce, if you wanted to go that far, introduce a proportionality assessment into Article 3 in immigration cases. As I said, that's why I posed the question whether that is still really something we would want to aspire to in 2025. But the difficulty I have with so that, and the court, of course, would treat that as binding. It's the law they have to apply, and therefore they would treat it as binding. Alternatives would be a declaration out of a ministerial summit, or which will also carry some sway, but of course that's when it is an agreed text between all the member states. Anything else becomes less effective, and the court will then have to look at who are the member states who make these statements, what's the context. I mean, we saw from the letter of 9, of course, that some of the parties to that letter are in fact in the middle of a pending dispute before the Grand Chamber about pushbacks on the borders of Poland and the Baltic states. One can question whether that's a sensible intervention when you're awaiting a judgment of the court, to tell the court not to go too far, but that's for others to judge. But I think the difficulty is, as I tried to highlight, is one, any of those changes are not going to change the numbers in any significant way. Just as there is case law, of course, under Article 8 and Article 3, which you can have an argument about whether the court went too far. I have no issue with that. But none of that's going to address the tens, if not hundreds of thousands of people who are said to be in need of being removed. And as again, I tried to highlight, I find it difficult to identify what the problem is that's being alluded to, because that's not where the number problem lies. And of course, yes, you can tie it to the living instrument, because that's been a red rag to a bull for a while now. But as I tried to highlight, when it suits, of course, also they need the living instrument to hold Russia to account, in inverted commas. So, and of course, the member states, and that's something where as I said, I have no sense of what the 16 are about. And it was rather confused reporting, at least what I've seen, because it then talked about needing the consent of the 27. And I thought, that sounds like an EU issue rather than and that, of course, comes to the next thing, that in migration, of course, certainly the 9 and the majority of the Council of Europe member states, their asylum and immigration policy is in large swathe defined by their obligations under EU law, which they've enshrined in directives and regulations, i.e. in written law, rather than having been created by a court. So I don't have an answer, but those seem to me the theoretical options. But my sense is that none of them would answer the numeric point which people are seeking to make.
Maybe just to pick up on that, but from a slightly different perspective, and you referred in your answer and in your lecture to this overwhelming or a significant support that the court has received in relation to the Russia-Ukraine case, including from states who take a very different view when there are individual applicants, perhaps from their own country, bringing claims against them. Does this, or should it have any bearing on how the court sees itself and its role and the role of the convention? Do you think it sees itself as sort of, do you think this is the first in a line of interstate cases? Is it a one-off? Is the court sort of going to be receptive to the reaction that it's received from states parties when it receives a positive reaction in certain circumstances and not in others? How do you see this playing out?
I mean, I don't think it will change how the court sees itself, in part because, as I've tried to highlight, the court has no choice as to what cases come before it and what cases it has to adjudicate on. And therefore, yes, member states may bring proceedings before the court and the court will have to decide them. But that won't change. I think the intervention by the 26th in the Ukraine and Netherlands against Russia case was an interesting, was a very interesting experience, and in many ways a very positive experience, because of course what was sought to be done was to try and help the court address a finding it had made in a finding it had made in Georgia Russia #2 about absence of jurisdiction in the context of the chaos of armed hostilities, to apply that or address that in the context of the conflict in the Eastern Donbass and the invasion. And there, the court was very appreciative of the efforts of member states, not only of the fact that so many member states intervened, but also that at the invitation of the court, unlike, for example, in the ICJ, we asked them to coordinate. And therefore, actually, they supplied, by and large, joint submissions, with a few states producing supplemental submissions. And in oral hearings, there were, they split the advocacy, but there was a set of submissions with 2 countries then making further and additional submissions. So that was seen as very helpful. Will it change the way the court sees itself or approaches itself? Difficult to see. And that's again where one of the similarities is. The court is, for all intents and purposes, and my continental colleagues will hate me for this, but is a common law court. It has a very small legislative base, the convention, and it is by and large applying the case law that's been developed since. And very rightly for a court of that nature, will only kind of break with precedent in the rarest of cases, because legal certainty requires that everybody can know the rules that govern their life. So no, I don't think it will change.
More questions about that? Yes, please. Christopher.
Tim, first of all,
can I say what a pleasure it was to listen to such a wide-ranging lecture on the court. My question is this. You mentioned the court, or the convention being a living instrument. And of course, that perhaps was visibly on display in the Seniorin case, in which you delivered a sole, but some in this room might think extremely powerful dissent. What is a country like the United Kingdom to do with a judgment like that? And in a sense, to whom, if I could ask, was your dissent addressed? Because I think that judgment, and you illustrate that very clearly in your dissent, it shows all the dangers of international, if you like, judicial overreach, judicial creep, whatever you like to call it. by international tribunals. And what can you say to, in a sense, about the majority judgment and how a country like the United Kingdom should deal with it?
Thank you for that. I think the first point to make is that my separate opinion was the result, or came at the end of some really intense deliberations in 3 connected cases: one against Switzerland, fine, Klimasenioren, and one against 35, I think in the end 34 states parties, Duarte Agostinho, and Harry against France, in which we had to deal with very difficult submissions in relation to, in Klimasenioren, which is the only judgment in Switzerland. And therefore, my separate opinion was an explanation why I disagreed with the vote the majority had taken on Article 8 and on victim status, but why I would have, or why I did vote for Article 6, but would have got there a different route. That always seemed to me to be the purpose of a separate opinion, rather than to send a message to anybody other than to enable me to explain to the world, to declare myself as the one who voted against it, because it seems to me that that is important for transparency reasons, and to explain why. Now, you ask what should a government like the UK make of that judgment? The same they make of any judgment that comes out of the Strasbourg court that isn't directly binding as a matter of international law in the UK. The Swiss circumstances were different, and therefore they will have to apply that judgment, or will look at that judgment. They don't have to apply it, but they have to have regard to it, and work out how it impacts on this, on the question they are having to address when they're looking at it. And that seems to me to be quite an important aspect of that. The other thing I think that is worth mentioning is that I think in April of this year or so, I gave a talk at UCL trying to take stock a year after we handed down the climate change judgment, what had happened, and whether my prediction of floodgates in relation to NGO applications, for example, had come to pass. And my prediction on that front had not come to pass. In fact, we had not even a handful of fresh applications it had in that year. The 2 applications that I think I identified at the time have since been rejected by a committee of 3 as being, as part of our well-established case law, inadmissible. In relation to the standing of NGOs, there was a question, would that go broader and now kind of infect the rest of the case law? In a case called Cannavacciolo against Italy, which is a large-scale environmental pollution case, the court went out of its way to make clear that what the court had found in Klimasenioren only applied in climate change, in the climate change context, and not beyond, even in something that some people might say was as closely related to climate change as you can be, namely the burying and burning, large-scale burying and burning of toxic waste over decades in the whole region of Italy. To me, that actually shows that, since that judgment was dramatic, the fact that there was only 1 dissenter was dramatic. But to use a tennis analogy, it was only the first serve. So I hope that sort of answers your question.
Yeah, so the last question over there, please.
Thanks so much, Tim. You focused in your speech on the facts and the staggering number of cases you dealt with in your time. I'm so glad you did, because genuinely just such an incredible, tremendous act of public service and international public service, that domestically and international public service, that we all owe a great debt, I believe, to you and your colleagues on the court. What strikes me, however, is that in terms of the current debates, where we are in the world right now, and general mistrust with international institutions, I know I'm generalizing, but just that general sense that we are in at the moment. I wonder whether facts and stats and the law are sufficient alone to tackle the narrative that is currently prevalent. And I wondered what your thoughts were on what is needed.
I agree with you that facts and stats alone are not enough. But I think they are an important, if not crucial, element of the debate, which is currently lacking, where in fact things are presented as facts which are either partially or wholly inaccurate to inform a debate and an agitation about leaving that is worrying as a trend. And we to some extent, and there's an element of education too. We saw, I think, 2 weeks ago or a week ago, YouGov did a poll which showed how little people actually know about the convention. And usually it's those who want to remain who know more about it than those who want to leave, was the result of the YouGov poll. This is me. What else is needed is a question which I don't think I've been away from the court and from my existence as a judge long enough to have an answer to. Because I think one of the things that this whole debate highlights is how courts really have, apart from providing the facts and the context insofar as they can, through their judgments, through press work, through other stuff, courts are not political bodies. And therefore it is not for them to engage in this political debate. If there is to be a decision to leave the United Kingdom, the court will have to accept it and will move on. Just of course, as the EU has moved on. If there is an amendment to the convention through a protocol, the court will apply it faithfully, as a court of law should and does. What the other factors are which help make this debate shape this debate in a more constructive way, I don't have an answer to. Sorry.
I think it's probably time to wrap it up there. So thank you again, Tim, and I'll just leave it to the audience to express their thanks in the usual way.